Our guest is attorney Charles Calenda. Mr. Calenda was a guest on this program in June of 2018 when we discussed the complexities of recently passed and proposed firearm legislation. A major focus was the so-called red flag legislation, which has provisions which are rather clear on one hand, but then very concerning on the other. Mr. Calenda was a member of the Attorney General's Department, where he specialized in prosecuting crimes involving firearms. He is now in private practice with the firm Inman & Torgey in Coventry. Welcome back to State of the State.
Thank you for having me, Richard.
Now, in 2018, the General Assembly passed and Governor Raimondo signed into law the Extreme Risk Protection Orders Act, otherwise known as the Red Flag Bill. Mr. Calenda, could you summarize this law for our audience?
Essentially, it was enacted to cover situations for people who the General Assembly believes should not have firearms, but were not otherwise prohibited by law. So in other words, they didn't have a felony conviction, they weren't involved with a domestic violence crime, something that made them an imminent threat if they had access to a firearm. It gives the ability of any law enforcement agency throughout the state of Rhode Island to petition the Superior Court in the state to seize the firearms of an individual who's deemed an imminent risk because of his access or her access to that firearm, seize those firearms. They can do it on an ex parte basis, which means that the person does not even have to be in court when they do it.
The person that owns the firearm.
Correct.
Yeah.
Initially, they don't even have to be in court. A judge signs that order, which also acts as a search warrant. And the police go to that person's home, serve them with that warrant, and seize their firearms. The law then provides that there shall be a hearing within 14 days of the initial order for that person to contest the judge's initial ex parte order, and the government would have to prove by clear and convincing evidence that that person is an imminent threat to himself or herself or others because of their access to firearms.
So this is really not, it is a Second Amendment issue, but it's also about due process and the seizure of private property by the government, right?
I would agree with that.
Okay. Let me present a scenario that I think will help illustrate what you're getting at. A high school student goes on a date with a senior. She's a freshman. Her parents tell her that there's a curfew. She breaks the curfew, comes back home several hours late, gets in an argument with her parents. Father says, "You're grounded for 2 weeks." The young lady stomps down the hall, slams the door to her room. The next day she goes to school and says to the school resource officer, "My father threatened me. He's got guns. I'm really afraid." School resource officer goes to the chief of police, says this is the situation. Chief of police says, well, we're going to go to court and we're going to get an order. Is that pretty much how that would work?
I mean, that would be a very unfortunate situation if that were to occur, but it is certainly within the realm of possibilities that that could be the case. While the law requires that a law enforcement officer be the sworn affiant of these petitions, they have to base it on information that they're getting. And in my opinion, and I think it's written into the law, at least if not explicitly, implicitly, that the law enforcement has to do their due diligence in making sure the information that they're presenting to the court is at least reliable. They've done some sort of investigation to corroborate this before they present to the court and start petitioning a court to seize private property from citizens, at least initially, without even a hearing.
Mm-hmm. You're spoken like a true lawyer, but in actual practice, in that scenario, a very distraught young lady goes to the school resource officer. It's kind of compelling when they go to the chief of police and say, I had this young lady who was very upset about this, and we better, what do you want to do? And they go to a court, and a judge can issue this. It's a temporary order, supposedly. The judge then issues, in effect, it gives them a search warrant and a cause for them to go to that home or place of business or whatever and say, turn over all your guns, right?
It does. It does exactly that. And in that particular situation, just in practice and in my years of experience, when you have a minor child going to a law enforcement officer saying, I'm afraid of my father and he's got access to firearms, I can't think of a situation where that information being presented to a judge would result in the judge saying, you know what, I don't think I'm going to do anything about that, unless there was something obvious or a major inconsistency in there that would lead somebody to believe that this was completely fabricated.
Okay, so what we're talking about is someone goes to the law enforcement. It doesn't have to be a child. It could be a neighbor they have a
Correct.
beef with.
Correct.
Goes to the police and says, I believe this person represents a threat and might do something bad sometime in the future.
Essentially, yes. When I call it the Minority Report law, based on the movie, and trying to predict bad behavior because the law does not otherwise give law enforcement the ability to seize these firearms from people, absent these statutory prohibitors that we all know about: convicted felon, crimes of domestic violence, habitual drug abuser or alcohol abuser. Those things would normally get them. But when people don't fit neatly into those categories, this law, I believe, was created to try to give them another alternative to say, we believe somewhere down the line you're going to do something bad, and your access to firearms is the reason why you're going to do that. And
the law does not require the person making the allegation, the affiant, as you refer to them, they don't have to sign this petition. This is a petition from a law enforcement agency. That the person actually making the allegation is not, required to sign it or anything else.
There's no requirement that they actually physically sign it. However, the officer has to attest to this in court. So it's in the officer's best interest to make sure that the information he's presenting to the court is going to be accurate and at least verifiable. But eventually, if there goes, when it goes to the full hearing, the person who has provided the law enforcement officer this information would have to testify under oath in front of the court if that hearing was contested.
So the law says, and I'm quoting, this order, referring to the temporary order, will continue until the hearing scheduled, and goes on to provide that the court shall schedule a hearing within 14 days of the issuance of a temporary extreme risk protection order to determine if a one-year extreme protection order should be issued under this chapter. Now, this law has been in effect for like a year and a half. How is it working in practice?
I can tell you, Richard, that it's been my understanding and seeing it in practice, these hearings are not happening within 14 days. And it's not because the person or the respondent in these matters is agreeing necessarily to continue it out beyond that 14-day period. A lot of these cases are being put down for what they call in practice status conference on the day when they're supposed to be going for hearing, the 14th day. So this person's been served with a temporary order. They're given a court date to appear, and the respondent is there either with or without counsel and says, I want my hearing. The judge, I'm understanding, allowed some of these judges who are hearing the petitions or are supposed to schedule to hear that hearing that day are not allowing the hearings to go through because they're saying, no, we're not going to hear it today. It's going to be for status. The parties are going to give them more time, and if they want a hearing, then we can come back in a few weeks and we can have the hearing. Effectively extending that 14-day period to whenever the court can find time to hear these hearings. Sometimes that's by agreement by the parties, but a lot of the times law enforcement is not able to bring the witnesses in. They're not prepared with their documents or whatever else they intend to present to the court in a contested hearing, and these matters are being continued by routine, which it goes against the shall part of that law. These hearings shall be heard within 14 days, and the only person who can waive that, except for good cause shown, is the respondent.
And so the respondent in this case is the person who's been accused.
Correct.
And so do we have one or more judges who are doing this? You're saying this is actually the status of how the law is being enforced?
I found that in many cases, this is how it's being practiced, even though the law does not specifically provide for that.
So in effect, this temporary order can become a permanent seizure of property without recourse, because there's no place else you can go. If a Superior Court judge says, this is just a status hearing, we'll hear it in the future, you can't go to the Supreme Court or anywhere because they're going to say that, well, the lower court hasn't ruled anything.
Well, you could petition the Supreme Court. It's a very onerous process. You could petition the Supreme Court for a writ of certiorari to say that the Superior Court judge is acting without authority and get them to basically issue an order to say, hold the hearing. You'd have to do that on an emergency basis, and I can tell you that it's very hard to get them to act on an emergency basis. But essentially, you could have to go through the hearing and then appeal that the procedure was not followed, and the Supreme Court could issue a stay of the Superior Court's order and then have them redo it or just reverse it entirely. But I will say one of the things that the courts are trying to get the respondents to agree to in these situations is, instead of issuing a full order that lasts for the year and that is contemplated by the law, they're saying, well, why don't we continue these ex parte orders for 2 or 3 months, sometimes even 6 months, and if you stay out of trouble, you do what we tell you to do, you go do your counseling, and we're satisfied that you don't present a danger at that point, we'll dismiss that temporary order. So there's no findings, there's no rulings, there's no taking of evidence. It's just a lot of people don't have the funds to hire an attorney, or they don't know how to fight these things, and it seems like the less I would say the less evil option to go with that and to say, oh, well, I can stay out of trouble for 6 months, or I can not do anything that scares anybody for 6 months, and that's how these are getting resolved.
And the other piece of this is that the respondent is taking time out of work if he or she is working, and has to go to these status hearings as long as they're scheduled, or else they're going to say, well, they're not here, so let's proceed.
Yes, and you know that the minute that the respondent does not show up to one of these status hearings, a full order is going to enter by default. And now you've got the full order held against you. You get your one opportunity to try to challenge that within the year, and it's. I don't know how many of those have been successful. I don't have any data on that. I can't imagine too many of them are successful.
Now, the law that was passed authorized the state police, in consultation with the Rhode Island Chiefs of Police Association, to, quote, develop rules and procedures pertaining to the storage and return of firearms seized by or surrendered to the local law enforcement agency or the state police. Now, this was put in, I was at the hearing when this was discussed. Within the Second Amendment community, there was a very great concern expressed that the police would not have any guidelines and that very valuable firearms would not be properly stored and cared for. And so this language was put in there. Now, I reached out to the state police and was told that the state police have their own procedures, and that they knew of no correlation or correspondence with local law enforcement agencies. So therefore, it is up to the local agencies to come up with their own rules and procedures of storage of these firearms that are seized. And also it talks about the return of these firearms. So this is just, I'm just don't know where to go with this question, because state police were authorized to do this, and apparently they don't think they have to.
Well, and that's very difficult to hear, because, as you know, the law basically provides for immunity for law enforcement if you believe that they're not following the law correctly, civil and criminal immunity. So the fact that they have not taken steps to ensure that these firearms are going to be safe kept really is leaving the person whose firearms are being seized without any recourse. Mm-hmm. You're hoping that the local law enforcement, who seem to be doing the bulk of these red flag petitions, are taking good care. And for the most part, I've understood that they have been. I haven't heard of any real horror shows like the guns have been destroyed or anything like that. But certainly the state police are reading this as well, we have the power to do it, but we're just not going to exercise that power. Mm-hmm. And I think that's alarming, because that provision of the law was put in there for a reason, and I just I don't know what their excuse would be for not wanting to be involved in that.
Yeah, and I think the concern is that local police departments, especially in the smaller towns, really don't have the capability to store a vast number of firearms. And somebody in their jurisdiction could have a very expensive collection of antiques, but they're still firearms subject to seizure, and then what do you do with them after that?
Certainly, the evidence locker space in these small departments is certainly not great. You know, the police, when I was an assistant attorney general, one of the questions we'd get from police often was, you know, is this case over? Is the appeal period lapsed so we can get rid of this evidence? Mm-hmm. And, you know, especially a small department, they're not going to be able to store large amounts of these firearms or any evidence for over a long period of time. So I really would urge the state police to be involved in this process so everybody's property can be protected.
Now, supporters of the Second Amendment are often portrayed as obstructionists who oppose any what are called common sense solutions to gun violence. And I think the red flag bill was in response to the Parkland, Florida high school shooting, where it was learned that the perpetrator had a history that would indicate a tendency toward violence. However, there was not unanimous consent or any kind of consent among the several mental health agencies to which that person was referred. Nevertheless, this is how he was portrayed in the mainstream media and on social media. However, isn't our system of justice based on the innocent until proven guilty and the idea that an accused gets to face his accuser, which does carry with it a certain amount of risk, but that's what our system is?
Certainly in the criminal justice system, and maybe perhaps the people who were advocating and were instrumental in the passing of these red flag laws are basing this on the fact that, well, this is not a criminal proceeding, this is a civil proceeding. But it's quasi-criminal in nature in the sense that if you violate any of these provisions, you're going to be charged with a felony, in some cases up to 10 years in prison. So it's, you know, it is a fundamental cornerstone of our judicial process that somebody accused with wrongdoing does get to face their accuser. So they do get the presumption of innocence, at least in the criminal sense. And the person bringing the allegations or the entity bringing the allegations always bears the burden of proof, particularly when you're looking to infringe upon a fundamental right. And the United States Supreme Court has held that the possession of firearms in one's own home for self-defense is a fundamental constitutional right. Mm-hmm. No different than your right to remain silent, no different than the right to be free from unreasonable searches and seizures.
The right to an attorney.
You're no different than that. But what a lot of the proponents of these so-called common sense gun laws, gun control laws, are saying, or what they're trying to do is basically relegate your Second Amendment rights to secondary status. Mm-hmm. They don't want it to be given the same sort of importance that the infringement of other rights, like your right to free speech or your right to an attorney, may carry with it.
Now, the phrase you used a little while ago, you talked about the state would, and if in a final hearing, they would have to have clear and convincing evidence. I think the law also says that at the conclusion of the 1-year holding period, the respondent, the person whose firearms were seized, can go to the court and petition to have them returned, but has to present, quote, clear and convincing evidence that he or she is no longer a threat. Can you explain to our audience the standard of clear and convincing evidence?
So in the law, there are basically 4 main standards of proof. The highest standard of proof is beyond a reasonable doubt. That's what the government has to prove to convict you of a criminal offense. Below that is clear and convincing evidence. And that's somewhere above more likely than not and below beyond a reasonable doubt.
Okay.
So whatever the judge basically finds that to be.
Okay.
Probable cause is below that. It's just more likely than that. And then reasonable suspicion is the lowest.
Okay. So it's like the second highest bar to hurdle over to get your guns back. Okay.
Yes.
Now, change topics a little bit because once again, Governor Raimondo and Attorney General Noronha have introduced the perennial ban on assault weapons in high-capacity magazines in both the House and the Senate. The bills are mirror images of each other. And the bill would allow someone who already owns an assault weapon as defined 1 year to register it with the local or state police, submit to a fingerprint background check, and pay a $25 fee per firearm. Wouldn't this create a registry of these guns that are deemed to be assault rifles to be used at some point in the future to confiscate them when they're deemed to be a public safety hazard? Or
Well, it certainly would create a registry. And right now, Rhode Island prohibits the registration of any firearms under current law. And it certainly could be used to track down people who may be in possession of these firearms at some point and target them, certainly if they're undesirable people or law enforcement so thought that they could be. So that would have to be changed under these proposed bills in order to allow for the registration. The biggest issue I have with this, and although I practice in this area of law, I certainly don't consider myself an expert on the actual mechanics of the firearms themselves. But the big question we should be asking ourselves is, do these laws substantially burden one's fundamental right to possess firearms in one's own home for the purpose of self-defense? And if you look at the definitions of what they consider these assault weapons are, this is really cosmetic. A lot of these things are not, do not make firearms any more dangerous than what they already are. A lot of these things are hunting rifles. The AR-15 is a perfect example. They call these things weapons of war, military-grade weapons. I can tell you, speaking to experts in this field, nobody in the military or nobody involved in a war is going to want a civilian AR-15 to be part of their arsenal. That is just simply, it's a fallacy. It's used to create fear, and it's used to push these types of bills through and saying this is just common sense. We don't need people having, quote, grenade launchers, at their disposal. I think they actually wrote that into the proposed bill.
Yes.
No grenade launchers.
Right. There was, we had Superintendent of State Police Jim Manny on this program a while back to discuss his work as the co-chair of the governor's working group on gun safety. And I held up a model of a AR-15, and we went through the characteristics. And there's several: flash suppressor, adjustable stock, a pistol grip that extends down, a heat dissipator, a bayonet lug, strangely enough, and a grenade launcher. Those are the characteristics that make up what the governor describes as military style or type weapons. Now, I pointed those out and I asked the colonel, which of these characteristics make this rifle any more lethal than any other semi-automatic firearm? And he pointed to the magazine and he said that. So essentially, one of these rifles without the magazine is nothing more than a single-shot rifle.
Correct. You put it in the chamber, one bullet comes out.
Okay. And this law also incorporates some areas, some shotguns and handguns in this new bill that's out there, the proposed bill. Now, with respect to these magazines, they call them ammunition feeding devices in the bill. Anything that holds more than 10 rounds, you have to dispose of it or render it incapable of holding more than 10 rounds within 180 days of the time the bill passes, or you face a fine of $5,000 and a prison term of not less than 1 year, nor more than 5 years. Connecticut enacted a type of ban where those who own them were required to register them and they could keep them, but they had provided they could not put more than 10 bullets in the magazine, which is kind of interesting. When someone's going to go use the gun for evil purposes, I'm sure he's going to observe that law. But the fact is that about 80% of the people in Connecticut that own them refuse to register. So is this a common sense solution to gun violence?
It's really not, and it can be said over and over again, and it's been said over and over again, that anybody who is out there to do damage, anybody who's out there to do harm to somebody else, is not going to be stopped by a piece of paper that says you can't do that. Anybody who wants to do it is going to do it. And, you know, there can be a lot of debate over what our response to that should be. However, what's really going on, like, this law is targeting firearms that are common in use, you know, handguns that are common in use, that are not any more lethal, that are not any more dangerous than a rifle, a typical rifle. And it's really just about getting firearms out of the hands of the general public for as much as they possibly can. I really don't see any other purpose behind these laws other than to make people feel good about doing something here.
The other interesting part of the law, we've got a few minutes left, but I did want to point this out to our audience and perhaps get you to comment on it. The bill provides that if the holder of a certificate that he's registered his assault rifle or weapon, if he should die, his heir or the estate has 180 days from the date of death to transfer the firearm to a licensed dealer or voluntarily surrender it to the local police or state police, or remove it from the state. If you don't do that, you have, the provisions of the law is you have a fine and you have jail time, makes you basically a felon. And I'm sitting there thinking about the widow whose husband maybe has one. The gentleman dies and she's got 6 months to figure, oh, the gun is hidden in the closet or something. It just seems so draconian to me to put these kinds of burdens on lawful gun owners.
Well, if you read some of the penalties that are involved in these bills, Richard, they are not only draconian, they don't give the judge much discretion, especially if it's not your first time. So if you had one gun that didn't do it and you got caught, so you get your felony conviction there, but they don't have to send you to jail the first time. The second time, your sentence can't be suspended, deferred, you can't get probation, and the judge can't overrule that. And these are the kind of penalties that they use for people who actually shoot people during crimes of violence. Mm-hmm. They're making them on par with failure to register or destroy these so-called assault weapons as written in these new bills. If they were to become law, you'd be treating these people no different than someone who committed a crime of violence and used a firearm to do so.
Getting back, I want to get back. Something just popped into my mind about this so-called red flag legislation is that if you do get a judge to issue an order to return your firearms, they have to be subject, you have to go through a background check. Now, one of the things on the background check is whether or not I've ever been arrested or charged with a crime of domestic violence. So it's a catch-22. Police can simply say, I didn't pass, if you don't pass, I'm not giving you the guns back, right?
And that's a big problem because in the case when you go to a federally licensed firearm dealer and you try to purchase a firearm, they do two checks. They'll state check and they do the FBI check, background check. There's a formal appeal process if the FBI or the federal check does not clear you. But I've seen a lot of clients come into my office, clear on the federal level. State level, there was a no from one of the local departments. And there's really no formal appeal to that because someone who's in law enforcement looking at your papers and making a determination, well, this disqualifies them. So it's really up to you to go find an attorney who can formally argue on your behalf to say, wait a minute, that doesn't disqualify my client. And I can tell you I've had some success with that, but a lot of the times your only option is try to go to court and get an order.
Well, ladies and gentlemen, I want to thank you for watching State of the State, and you will see Attorney Calenda's contact information. And if you have this problem, please give him a call. And stay tuned for future editions of State of the State.